Hi everyone, welcome to Andy on Crime. Following the cases of Thomas Cashman and Jordan McSweeney, who murdered Olivia Pratt-Korbel and Zara Alina, both of the defendants refused to attend their sentencing hearing where they were given life sentences for those murders. After this case, there's been a call from the families and a proposal put forward by the Ministry of Justice to in effect force defendants, killers and other serious offenders to attend their sentencing hearings. Now in this video I'm going to explain why I think that this is a bad idea. Now before I get into the practicalities of why I think that this is a bad idea, I do firstly want to say that I absolutely understand the hurt and the pain that the families would have gone through, not only losing that member of their family, but also having the defendant being able to avoid listening to the victim impact statements that would have been read and understanding the hurt and the distress that they've caused as a result of their actions. So I place no blame whatsoever on the families wanting the defendant to be present in these cases. The first reason why I think that practically this is a bad idea is that if you are forcibly bringing someone into court against their will, you are creating a risk of harm to the security staff and the court staff who may have to deal with violent and angry outbursts by the defendant. Now, security staff and court staff do a dangerous job and deal with dangerous people on a daily basis, but they have a right not to be exposed to additional risk by a defendant who is being forced to attend a sentencing hearing that he does not want to attend. The second reason why I think that this is a bad idea is that if you force someone into court against their will, and albeit they're not being violent towards the court staff, you run a significant risk that the defendant will be disruptive during the sentencing hearing. And you want to avoid a situation where family members of the deceased are giving a victim impact statement detailing the harrowing consequences of the defendant's actions in murdering a member of their family. You run the risk that the defendant who is being forced to be there will be disruptive, will shout, swear, be angry, and generally cause the sentencing hearing to be unable to be conducted properly because of their actions. Now, in normal criminal trials, a defendant who is continually disruptive during the hearing will be given several warnings by the judge, but if their behaviour is such that they cannot continue the case, the defendant will be taken down to the cells and the case will proceed in their absence. The third point to make is that the Ministry of Justice proposals want to add additional years onto an individual's sentence if they refuse to attend their sentencing hearing and remain in their cells, as a way of acting as a deterrence against people refusing to appear in their sentencing hearing. What I would say about that is that the types of cases that we are talking about involving murder are the most serious cases that are dealt with in the criminal justice system. And where someone is being convicted and sentenced for murder, they will automatically receive a life sentence and then will likely receive a tariff in excess of 20 years. And if we take the case of Thomas Cashman, who murdered Olivia Pratt-Korbel, he received a life sentence with a minimum term of 42 years. The deterrent effect that 3 or 4 years would have had on Thomas Cashman attending his sentencing hearing would have been non-existent, because essentially 45 years or 42 years, there's very little difference when we're talking about that length of sentence. So I don't think in the types of cases that we're talking about, a threat of additional years onto your sentence is going to have the impact that the Ministry of Justice think it will have. The fourth point to make is that there are alternatives to new legislation to try and alleviate this issue. One practical solution would be for the defendant who is refusing to come to court to appear via a live link from the prison that they're in, and this logistically would remove the need for the individual to be removed from prison, transported to the court itself, and then brought up into the courtroom against their will. The individual could appear on a live link and be muted, but would have access to the sound from the courtroom. So no matter the disruption that the individual is causing, the courtroom would not be affected by that disruption, but the individual would still be able to hear the victim impact statements and the sentencing of the judge in the judge's sentencing remarks. So to summarise, the first reason why I think that this is a bad idea is that effectively dragging someone into court creates a risk of violence being used and injury being suffered by the security staff, who will have to bring that individual into court against their will. The second reason is that even if the individual comes into court and doesn't commit any acts of violence towards the security staff, there is a significant risk of disruption being caused. And this is particularly bad during the victim impact statements being read out by the family members, who are talking about the impact that the defendant's actions have had on them. The third thing is that the deterrent effect that the Ministry of Justice thinks that additional years on someone's sentence will have, in my opinion, would be negligible. When you're dealing with cases involving life sentence and several years in prison, the impact of additional years on top of that is likely to not have the deterrent effect the Ministry of Justice think that it will have. And the fourth point is that there are alternatives to new legislation, such as requiring the defendant to be present on a live link where they can hear the court proceedings but cannot disrupt it because they're muted from their side. Let me know what you think in the comments below. I know some people will be happy for a Hannibal Lecter style drag into the courtroom, but I do not see that that's what's going to happen. And some people will be disgusted by the fact that defendants can refuse. But I think that for the reasons I've outlined, there are practical reasons why this piece of legislation that the government are proposing is not the right way to go about it. Thanks for watching. I hope that you found this video informative. If you did like the video, please consider giving it a like. And if you'd like to see more content from me, please subscribe to my channel. Thanks for watching. Take care.